Carlos Mendez, a 38-year-old Phoenix roofer employed by a subcontractor, fell 18 feet from an unmarked, unguarded scaffold opening at a new luxury residential development in Paradise Valley in November 2025. He fractured his pelvis, both wrists, and suffered a traumatic brain injury. Workers' compensation paid $2,200 per week, far below his previous income. The general contractor's site supervisor told Carlos's wife, "Workers' comp is all he gets. He can't sue anyone." That was wrong. Carlos's family had been told the same thing by 3 neighbors and 1 coworker. Workers' comp is the only remedy. You can't sue. They didn't know there was a critical legal distinction between suing his direct employer, barred by workers' comp exclusivity, and suing the general contractor, property owner, or equipment vendor who independently caused the hazard. They were about to accept $2,200 per week for a man who would need a wheelchair for a year and lifetime cognitive rehabilitation. They needed someone to explain Arizona's third-party liability exception. Before they signed anything, Arizona's workers' compensation system under ARS Section 23-1023 provides an exclusivity bar that prevents employees from suing their direct employer for on-the-job injuries. However, this bar does not extend to third parties, including general contractors, property owners, and equipment manufacturers who independently create or fail to correct unsafe conditions. Under Arizona OSHA regulations, AACR 20-5-601 at CQ, general contractors bear non-delegable duties for fall protection at multi-employer construction sites. OSHA 29, CFR Section 1-926.502 requires guardrails or covers on all scaffold openings above 6 feet. A general contractor's failure to enforce fall protection on its site, even for subcontractor workers, creates independent tort liability in Arizona. Carlos's attorney named the general contractor and Paradise Valley property owner as defendants, alleging violation of AACR 20-5-601, OLHA duties, and premises liability. Separately, the scaffold component manufacturer was joined for a product defect claim. Discovery revealed the general contractor had received 2 prior written OSHA warnings about unguarded openings on this same site. A neurological economist projected lifetime cognitive care costs at $1.1 million. After 20 months, the 3 defendants settled collectively for $2.15 million, far exceeding what workers' compensation alone would have provided over a lifetime.